Does that make sense?
No.
We were just watching the prior testimony of Dr. Noel Palmer, the medical examiner in the Matos case. Now, we saw some of this earlier today when we replayed these clips this morning before trial was in session. I mean, there was some really graphic testimony. We didn't see photos that like what we've seen in other cases, but we've heard some really horrible sounding stuff about the gunshot wounds, asphyxiation, the fact that hammers were used on the victims in this case. I mean, it was very difficult testimony to hear when you're talking about the nature of the physical injuries. What we just watched there and what we're revisiting is the cross-examination of Dr. Palmer by the defense, with some questions really revolving around the fact that Dr. Palmer couldn't really pin down the sequence of events or the sequence of the injuries or even the timing that when these injuries occurred. So that is certainly some form of defense strategy. We heard the prosecution redirect, asked to conduct some additional questions regarding the doctor's expertise and what he believes might have happened. And really the defense seeming to have the strategy of just breaking down that ME report couldn't really establish exactly what happened to the victims. To discuss this further, I have Julie Rendelman. She's a LawNewz trial analyst. Julie, so what do you think is happening here? Because obviously we know that these people sustained some significant injuries up to their death. We also know that one of the bodies, and maybe this is what the defense was trying to capitalize, one of the bodies was very decomposed. That's Gregory Brown. So perhaps the cause of death couldn't necessarily be established. But is there any question that the cause of death in this case is murder or not natural causes or
no,
something
and
of the
I
like?
don't know that he's going down that road as much as he's trying to poke holes in. Look, we have the prosecutor has a theory and has a timeline as to when things happen and potentially a timeline as to when deaths occurred. And I think what he's trying to do, and again, my guess is what he's trying to do is he's trying to establish that you can't prove the time of death through these bodies. And, you know, it just makes it a little weaker in terms of the prosecutor's theory. And look, the argument is the reason you can't establish the cause of death for at least some of the bodies is because they're so decomposed. It sounded like they were maggots on some of the bodies, and so it made it much more difficult for the forensic examiner to make a determination as to when these individuals died, or the order of which they died. And I think he also is questioning kind of the medical examiner in terms of the specific causes of death, perhaps just to maybe just poke some holes in terms of some of the theories, although I don't think the prosecutor needs to prove that any of these individuals were killed in any specific way other than they were intentionally killed.
Right, and that seemed to be a focus of the defense attorney, though, because a lot of the testimony or the defense attorney on cross-examination was trying to get out that the medical examiner didn't really know in what order these injuries occurred. Julie, can you give us some insight? Why would that be the strategy other than to just cast a little doubt on the timeline?
I don't know. I mean, again, you talked about self-defense. Is it possible that, he asked it one question, well, if someone's hit, wouldn't they be down already? And so, like questions like maybe he's going with self-defense, maybe he's going with self-defense as to one or two of the individuals that died. I have no idea. But he did, look, the medical examiner, I've seen many medical examiners testify. He probably wasn't the best in terms of his articulation as to what happened. I think we were both joking about kind of the comment he made in terms of when you hit an individual that's dead. He said, what would be the point of hitting an individual that's dead, which isn't really a medical conclusion. And then it seemed like, I understand he's not an expert on blood spatter, and no one expects him to be, or blood splatter. Blood spatter. Wait, now I can't. Blood spatter.
I know, now we're having trouble saying the word.
But it almost seemed like he didn't even know what he was talking about when he talked about that. And so, he's certainly not making the medical examiner look that great in front of the jury, but I don't think it really matters at the end.
Right. It doesn't necessarily matter at the end of the day, but certainly any sort of ammo that you have to undercut the prosecution's case. And oftentimes the medical examiner aspect, the testimony, is really critical to the defense case.
Absolutely.
Just in this particular situation, you have some very severe injuries that we don't know what order they happened,
exactly.
but we know that
they happened. Right.
So another interesting thing that I was thinking about, and it has to do with that comment that the medical examiner made, which is, why would you hit somebody 21 times after death?
Right.
So the question that was posed by the defense attorney was, could Leonard have received these injuries after loss of consciousness? Now, to me, that's almost problematic for the defense to say that this guy went to town on him after he died. I mean, isn't that something that would be taken into consideration in the death penalty, in the penalty phase of the case?
I mean,
would say this is excessive, and this
certainly it blows the water out of any self-defense, although we were guessing about that being a possible defense. But absolutely, when we're talking about the brutality, I mean, look, one would argue in terms of brutality that he wasn't awake, so he wasn't conscious as to when the various injuries were being inflicted. But another argument, which I think is a stronger argument, is that you can't get more defenseless than when you're unconscious. So if you continue to beat an individual when you're unconscious, that just shows an absolute disregard for that individual's life.
Right, and we know that in cases where the death penalty is sought, the brutality aspect that we're talking about, many times it's if the perpetrator did something to the body post-mortem that would say that it was an extra egregious offense or extra egregious killing or extra brutal. So that, to me, was almost a mistake on the part of the defense attorney to even highlight that fact that could be an issue.
I guess the argument that they're making, and again, it's unclear, is because the body was so decomposed, you can't tell whether anything is post-mortem or not, because usually there are many situations where you can tell if something was inflicted post-mortem or not. And so perhaps they're just simply going with kind of the theory that the medical examiner just doesn't know when and how these injuries were inflicted, and therefore kind of throws off some of the prosecution's theory of the timeline.
Yeah, that really seems to be the case, because the best bet that defense has is, look, if you can't establish when these people died or exactly how they died, and then their bodies are found somewhere else.
Right. By the way,
maybe that's something, reasonable doubt.
And we're also kind of, I hate to say this, and this is not any type of negative on the part of the defense, but sometimes the defense doesn't have a strategy. They just cross-examine for the holes that they're finding and seeing if once they cross-examine, if that gets them anywhere. So we always assume that they're doing it for a reason. Sometimes they're just doing it because
you get in the zone,
let me ask these questions and let me see if it gets us somewhere, and then we can think of a strategy later.
And that certainly could be the case, that if they saw the medical examiner's testimony, saw that there could be some potential weaknesses in comparison to the medical reports about the timing, or a question mark as to what the actual cause of death for each person was. Because we know that during the direct, which we reviewed earlier today, yes, there had been some more solid conclusions made on the part of the medical examiner. Well, this is asphyxiation. This person died of a gunshot wound. There's all this other stuff, but that's what happened.
Exactly.
Well, then the defense comes in, they cross-examine, they say, well, couldn't it have been XYZ? You found all this other stuff. So it seems like that's the direction that the defense is going in. And again, you got to go with whatever you have.
Right, exactly. And they don't have control over kind of what the evidence is against this individual.
No, they certainly don't. And we are interested to see exactly where this goes as time goes on, when we see the defense put on their case. While we wait for trial to come back into session, which we anticipate will be in about 15 minutes, we're going to continue to review some of the prior testimony. This is Nancy Solinsky. She's the forensic investigator. Her testimony starts out strong, talking about an odor that was identified in the house that, in her experience, could only be caused by decomposing bodies. So we're turning to that testimony now.
Introduce yourself to the jury.
Hi there, my name is Nancy Solinsky.
And Ms. Solinsky, how were you employed back in September of 2014?
As a forensic investigator for the Pasco Sheriff's Office.
And how long were you a forensics investigator for the Pasco County Sheriff's Office?
I became an investigator for the Sheriff's Office in June of 2006.
And what are your duties as a forensic investigator?
So duties as a forensic investigator is we respond to various types of crime scenes. And our duties there are to document the crime scene as is. We collect various items of evidence and process the crime scene as needed.
Now, back on September 4th, 2014, on a Thursday, did you have occasion to get involved into an investigation of 7719 Hatteras Drive and surrounding circumstances?
I did.
And Judge, may I approach the witness?
You may.
Now, Thursday, September 4, 2014, did you respond to a tow yard?
I did.
And I'm showing you State's Exhibits 438 and 439. Could you look at those? Do you recognize those?
I do.
And what are those?
These are photographs of a vehicle that was at that tow yard that I responded to.
Okay. And once you responded there, did the Sheriff's Office take possession of that vehicle and take it back to the forensics lab for further examination?
Yes.
And these photographs, are they of this truck as it was found with the blue tarp over it?
Yes.
Okay. And fair to say that that's a blue truck
It is a blue truck, yes.
with license plate 244JJN?
Yes.
This time, Judge State would like to move State's Exhibit 438 and 439 into evidence.
Any objection?
No, Your Honor.
All right, 438 and 439 will be in evidence.
Permission to brief the public, Judge?
You may.
That same evening, did you also, actually, I'm sorry, real quick, let's go to September 5th, 2014, Friday. Did you go to a residence on Woodchuck Way that was identified to you as Nicholas Leonard's residence?
Yes, I did.
Would you call the address of that residence?
I don't remember off the top of my head the address, the numerical. I'd have to refer to my notes if I may.
Would that refresh your recollection?
Yes.
Please do.
One 2721 Woodchuck Way.
And I'm showing you State's Exhibits 440 through 443. If you could look at those and tell me if you recognize those.
Yes, I do.
And what is State's Exhibit 440 of?
That's a photograph of an end table in the master bedroom.
Okay, and there was a bed next to it.
Yes.
Fair and accurate depiction of the way you found it.
Yes.
State would ask to move State's Exhibit 440 into evidence.
Any objection?
Wait, Your Honor.
Okay, 440 will come in.
Showing you State's Exhibit 441. What's that of?
That's a photograph of the same nightstand with a gun box on it.
And what does the gun box say?
It's a Keltec.
This time, State would like to move State's Exhibit 441 into evidence.
Any objection?
No, Your Honor.
All right, 441 will come into evidence.
Permission to publish, Judge?
You may.
Turn your attention to Stage 442. What is that of?
That's the same gun box that I was just speaking of. It's opened now.
And once you open the gun box, what'd you find?
The gun box is empty.
Okay. And turn your attention to Stage 443. What is that of?
That's a photograph of a box of ammunition,
And what type of ammunition was it?
a Federal 380.
And was the box of ammunition full?
No, it was not full.
Were there different types of ammunition in it?
It appears that it's all the same type of ammunition.
Okay. This time, Judge State would like to move State's Exhibits 442 and 443 into evidence.
Any objection?
No, Your Honor.
All right, 442 and 443 will come into evidence.
Permission to publish?
You may.
Ms. Walensky, I want to show you State's Exhibit 487 for identification. If you could look at that and tell me if you recognize that.
I do recognize this.
What is that?
This is that gun case that I was just speaking of that was in the photographs.
At this time, Judge State would like to move states 487 into evidence.
Any objection?
No, Your Honor.
All right, 487 will come into evidence.
Could you do me a favor? Does it have a label on there right there at the bottom that has some numbers starting with JS?
It does. Would you like me to read them?
If you could.
It is JSD, like David, 28.
Thank you. Now, Ms. Zielinski, did you eventually respond to 7719 Hatteras Drive?
Yes, I did.
And I guess I would say on September 4th, but it was really past midnight into September 5th of 2014. Is that fair?
I actually responded on the 4th. It was about 10:30 at night when I responded there.
Very good. And when you responded there, did you notice any odors about the residence?
I did.
And can you describe to the jury what that smelled like?
The odor was a very strong, putrid, rotten odor.
And is it an odor that you're familiar with?
It is.
And being a crime scene forensics investigator for as many years as you have you been to many different death investigations?
Yes, I have.
Have you encountered decomposing bodies many times in the past?
Yes, I have.
Is it a smell that you are familiar with?
It is.
And what the smell of 7719 Hatteras Drive, how would you describe that smell?
It was a smell that smelled like decomposition. It was a very strong odor.
Now, at 7719 Hatteras Drive, did you spend a substantial amount of time, or were you the primary forensic investigator who dealt with the east garage in the residence?
Yes, I was.
I want to show you State's Exhibits 444 through 459. If you could look through those for me and tell me if you recognize those.
I do recognize these.
Are those all photographs of the east garage of 7719 Hatteras Drive?
Yes, they are.
They fairly and accurately depict things you saw in that garage?
Yes.
This time, Judge State would like to move State's Exhibits 444 through 459 into evidence.
Any objection?
No, Your Honor.
All right, 444 through 459 will be admitted.
I'm going to ask you a little bit more about luminol and Blue Star in a minute, but in terms of luminol and Blue Star, did you do some processing using those chemical agents within the residence?
I did.
And I'm showing you State's Exhibits 460 and 461. Did you assist in doing some processing with luminol in the west garage?
Yes, I did.
And 460 and 461 photographs depicting some of the things you observed when you did that.
Yes.
This time, State would like to move State's Exhibits 460 and 461 into evidence.
Any objection?
None.
All right, 460 and 461 will come into evidence.
Showing you State's Exhibits 462 through 464. If you could look at those for me. Do you recognize those?
I do.
And did you assist in processing the door that led from the west garage into the stairwell area of 7719 Hatteras Drive?
Yes, I did.
And are these photographs, states 462 through 464, photographs of what you observed when you did process that door?
Yes.
This time, state would like to move states exhibits 462 through 464 into evidence.
Any objection?
No, Your Honor.
All right, 462 through 464 will come into evidence.
Did you assist in processing the stairwell area with luminol?
Yes, I did.
And I'm now showing you states exhibits 465 through 468. You look at those for me. Do you recognize those?
Yes, I do.
Are those things that you observed once you assisted in processing the stairwell area with luminol?
Yes.
They're inaccurate depictions?
Yes, it is.
At this time, Judge, State would like to move states exhibits 465 through 468 into evidence.
Any objection?
No objection.
All right, 465 through 468 will come in.
Turning your attention to the southeast bedroom on the second floor. I'm going to show you states exhibits 469 through 479. Did you assist in doing some trajectory analysis in that southeast bedroom?
Yes, I did.
And are those photographs that you just reviewed, do they depict what you observed when you did some of that trajectory analysis in the southeast bedroom?
Yes, it does.
At this time, they would like to move states exhibits 469 through 479 into evidence.
Any objection?
No, Your Honor.
All right, 469 through 479 will be in evidence.
And did you assist in doing luminol in that bedroom as well?
I did.
I'm showing you states exhibit 480. Do you recognize that?
I do.
And is that what you saw after application of luminol in the southeast bedroom on the second floor?
Yes, it is.
This time, so would like to move states exhibit 480 into evidence.
Any objection?
No, Your Honor.
All right, 480 will be in evidence.
Showing you states exhibits 481 and 482 for identification. Did you assist in doing some luminol application in the master bedroom on the second floor?
Yes, I did.
And do those photographs depict what you observed when you did that?
Yes.
This time, state would like to move states exhibits 481 and 482 into evidence.
Any objection?
No, Your Honor.
481 and 482 will be so moved.
Showing you states exhibits 483 and 484. Are those from the master bedroom closet after some plywood floor was removed?
Yes, it is.
Fair and accurate depictions.
Yes, it is.
I'd like to move states exhibits 483 and 484 into evidence.
Any objection?
No, Your Honor.
All right, 483 and 484 will be in evidence.
I'm showing you states exhibits 488 and 489.
Just go down. Go back to
488 and 484.
488 and 489. Did you take some photographs in the living room area of 7719 Hatteras Drive that are depicted in those two photographs?
Yes, I did.
Fair and accurate depictions of what you observed?
Yes, it is.
This time, state would like to move states exhibits 488 and 489 into evidence.
All right, states 488 and 489 will be in evidence. Oh, like, hold on. Any objection?
No, Your Honor.
Okay, they'll be in evidence. Sorry.
All right, Ms. Zielinski, could you tell the jury a little bit about what Blue Star and luminol are and why they're used?
Sure thing. The luminol and Blue Star are pretty much the same thing. There's a couple of different chemical differences, but the reason that we use it, forensic investigators use it, is to be able to detect trace amounts of blood or blood that's already been cleaned up. It's a very sensitive type of a chemical, it reacts with 1 to 1 million parts of water. So to put that in perspective, it would be about 1 drop of blood in, say, a 13.2 gallon area. So this chemical is able to detect 1 drop of blood in 13.2 gallons of water. So even though it's been diluted or if blood has been cleaned up, we're still able to detect it using this chemical.
Okay, and when you say detect it, what does it do in order to allow you to detect it?
It creates a visual reaction. It's a chemical luminescence is what it's called. And it almost is like a glowing. So we'll have to do it in complete darkness. So that's going to be able to help us visualize something that we can't see with the naked eye.
All right, and were you involved in processing this residence with luminol and or Blue Star in multiple different locations?
Yes.
In particular on the bottom floor.
Yes.
Now I want to show you Stacey Exhibit 490 for identification. Do you recognize that?
I do.
Is that a diagram on the bottom floor of the house?
Yes, it is.
Now, would you be able for me to highlight or draw on there some of the different areas that you observed on the bottom floor that luminesced after Blue Star application?
Sure. You want me to draw right on this?
Yes, go right ahead.
So
Welcome to the Law News Network. I'm Misty Maris. We're here waiting for the Matos trial to come back into session. It was scheduled to come back around 1:45. We see some activity in the courtroom, but we're waiting for court to actually begin. In the meantime, we've been reviewing some testimony that we heard earlier today. We listened to the medical examiner's testimony, who the defense was trying to poke some holes to say that the medical examiner couldn't actually identify what the cause of death was or the timing of the injuries sustained in all 4 of the victims. We were just listening to the forensic examiner who had some very, we didn't see any photos, but we heard some kind of graphic testimony with respect to the smell that she encountered when she arrived at the house, and described that in her experience as a forensic examiner, and that she's done this hundreds of times, this could only be the smell of death. I'm here with Julie Rendelman, LawNewz trial analyst. We're just breaking down what we've seen in the trial so far. So Julie, we're still here. The prosecution's case in chief is still on. This morning we saw a few coworkers of Margaret Brown. So that's Megan Brown's mother. Obviously the prosecution trying to establish a timeline and perhaps filling in some other facts with evidence of witness testimony.
Sure.
We don't know who's on tap yet next, but we do know that certainly this timeline is at issue for both the prosecution and the defense. That's really where the defense was going with the cross-examination of the medical examiner.
Right.
And of course, the prosecution told us what they believe happened. So how compelling is it from a defense perspective that they're able to say, look, you can't really identify the exact cause of death and you can't really identify when it happened? Is that going to hold any water?
I don't think it's very compelling, and quite honestly, I think that the jury could even accept that the prosecutor's timeline isn't perfect and still believe beyond a reasonable doubt that Matos is the individual that killed these 4 individuals. I don't think you have to, I mean, look, the timeline is helpful because it helps establish kind of when people disappeared and how that relates to kind of the house and where Mr. Matos was. But I don't even believe that the prosecutor has to show their case in terms of that timeline perfectly for the jury to buy that he killed these people.
Right, and we also know from that interview, the jailhouse interview that was conducted when Mr. Matos said, look, there's this other person.
Right.
He identified someone who could potentially be at play in this case, and we heard the defense drop that name. He also admitted in that interview that he was at the house on August 28th. I mean, that's the day in question.
Right.
This is the day that Margaret doesn't return home from work. We see her at the convenience store that she works at. We watched that video footage today. It's supposed to take her 15 minutes to get home. We don't know what happens. We hear a call from Megan Brown to her boss saying, I'm scared to come to work because Matos had threatened me. I thought he might take our child and all of this. And then later that day, Megan Brown gone. And now you have that statement. So hypothetically, say, and obviously stuff you say in the media, that can come into the courtroom, right?
It absolutely can. I don't know that they even need it. I mean, I hate to say that they, it's always stressful as a prosecutor to have no evidence. It's equally stressful to have too much evidence because you just can't lose. But certainly they can use the media. I don't think they need it to prove their case. But it certainly indicates that he was at the house. And also you have a neighbor who sees him at various times throughout those days, that can establish that he was in the house, to establish that he would at least have noticed the smell coming from the house that seemed to be so clearly the indication of dead bodies that even the forensic examiner knows that this is what it is.
That was it. The forensic examiner, we just heard her say that the smell was so overwhelming when she walked into the garage area that there was just no other explanation for it. I mean, can he possibly say, oh, I didn't notice it?
I mean, he has something wrong with his olfactory.
It must have to be something pretty severe in that case. But
no, and it's just not. It's not going to work for him. Also, keep in mind, I believe he fled afterwards. You know what I mean? That we keep forgetting. It's so funny that we forget to bring up other pieces of evidence because there's so much. But we forget that he was found in a hotel with his child, not at the house anymore, and so these are other pieces of evidence that establish that there was some consciousness of guilt in regards to what had transpired that day.
Yeah, this is such a tough case for the defense, and you're right, we were focusing very much on that August 28th day and the events of that day because that's some of the testimony we heard earlier this morning relating to Margaret and Megan Brown's whereabouts during that time period. But what about after the fact? So here's some of the facts that we know. About 12:30 a.m. on Friday, August 29th, you have a neighbor who sees Matos at the Brown home. Matos is out of breath, sweaty, comes over and strikes up a conversation. I mean, already you're having these issues. Well, it's going to certainly be an interesting trial to watch unfold as we see what the defense intends to put on as far as their case is concerned. Since we didn't get an opening statement, we don't really know what that's going to be. But right now, it looks like there's some activity in the courtroom, so we're going to go to the Florida courtroom live. So, Julie, we see that the jury is on their way in. It's taking them a little time to get seated, but we know that the prosecution is going to continue their case today. What do you think the defense is going to capitalize on in this case? I know we've talked about it a little bit, that there could be some sort of alternative theories, that we do have this mystery person who's been dropped into the mix.
Sure.
Are there any other facts that you've read about with respect to this case? And granted, a lot of this is not stuff that's come out in the courtroom.
Sure.
It's what the media has reported.
Right.
That you think the defense could hitch its wagon to at this stage of the game?
I mean, I hope they don't hitch their wagon to the idea that there's another stalker that's involved in this, just because I think it will get them nowhere and I think it will hurt them at the sentencing phase. And the only other option I see, which we've talked about, is some type of, not mental disease that rises to the level of him not being guilty, but some type of snap, either that he snapped on that day that somehow mitigates in some way the jury's kind of viewing of him being an absolute monster.
Yes, and you bring up a good point. So when you're talking about bringing up some sort of, yes, I snapped, and we've seen that before, that wouldn't absolve him of guilt. That would be a mitigating factor. Perhaps he could be found guilty of a lesser included offense?
Right, he could be, and I don't know, just so you understand, I don't know the specific laws in regards to the lesser includeds of murder in this specific jurisdiction. Yes, he could get a lesser. Quite honestly, I'm more talking about the idea that the jury just won't absolutely despise him when the sentencing phase comes up, and I admit that I'm already there, unless something, and I'm trying to keep an open mind, but I'm already past it, just because so far to me the evidence is overwhelming, but I will attempt as best I can to sit tight and wait.
Well, certainly in a death penalty case, that is something the defense has their eye on. They're
Right.
not just limited, they're not looking at this case in a vacuum, right? They're looking at the end game. The end game is probably to save their client's life.
Right.
So certainly that could explain, your theory could explain why we didn't hear an opening statement where the defense was articulating an alternative set of facts in response to the prosecution. Instead, they'd rather see what the evidence holds,
Sure.
poke holes in that case, bring up facts that may tend to raise some doubt, or, as you said, maybe shed their client in a different light that the jury will not be inclined to go for the death penalty.
Now, I don't know that the defendant is necessarily on the same page as them, because, many times the defendant's viewpoint of kind of how the evidence looks is not necessarily the same as the attorney's. And so, but, there's no way for us to know. We may know if the defendant ends up taking the stand as to kind of, whether it was his strategy or the defense attorney's strategy as to what their defense was going to be.
Right, and if he does take the stand, perhaps that's the only way. And I am with you, Julie, and as a general principle, it can be a big problem to put your client on the stand, and it's something you have to think long and hard about. But some of these actions that Matos took after the deaths of these 4 individuals, just as we spoke about, what we saw with the neighbors selling the dogs, running away, ending up at this hotel, all of this, ordering pizza to the house, using
Right.
Megan Brown's debit card. I mean, this is really solid stuff for the prosecution. Is there any person on this earth that can explain those actions but him?
No, except I am curious to know whether or not they ever pursued some type of mental disease or defect defense and either found that that the doctor didn't go along with it or something, just because that seems to me to be kind of the only alternative in terms of kind of mitigating or lessening the impact of kind of these absolutely horrific crimes. I don't know if I didn't see anything regarding that, but that seemed to me, if I was the defense, to be the only way to kind of, to try to save his life. But he may have been very well against that. Who knows?
Yeah, we don't really know. Another fact, going back to this stalker, this person that was brought up in this jailhouse interview with Matos, that we know the defense at least has them on their mind because
Right.
the name was dropped into. Oh, wait a minute, Julie. Hopefully we'll be able to discuss this, but it looks like court may be coming back into session. One thing about that particular person, that stalker, the defense could potentially argue that they were never properly investigated, perhaps call the investigation into question.
They could. It would depend on, the question becomes, who is it going to come out through? And so, when we talk about the defense's case, there's going to be an investigator, or I'm sure numerous investigators that testify on the people's case. And so if that's going to be their strategy, one would assume that's going to come out in cross-examination as to whether or not they kind of made sure that there were no other potential suspects that they ruled out.
Yeah, only time will tell. It looks like the jury and the judge is on the bench, so we're going to go live.